Number 21, Cordero versus Transamerica Annuity Service Corporation. Proceed, counsel.
Good afternoon, Your Honors. Scott Eisman for Cordero. I'd like to reserve 3 minutes for rebuttal.
You have it, 3 minutes.
Transamerica breached the implied covenant by blindly cooperating with factoring companies to transfer away Cordero's structured settlement payments.
Counsel, what's the breach, though? Is it that they didn't object or that they didn't consider objecting?
The breach is really that they didn't consider anything at all. They did absolutely nothing here. And to understand...
So if they had looked at this and said there was a record and they said, nah, we think this is a pretty good deal, that would be okay.
There might be a factual question whether their consenting there rather than withholding approval was in good faith or not in good faith. But at a minimum, they had to
Did they
exercise...
have a contractual relationship or a fiduciary relationship with Cordero?
They had a contractual relationship, Your Honor. And
so why were they obligated to stop the sale?
They weren't obligated to stop the sale because of any sort of best interest determination or because of typical fiduciary duty considerations like owing Cordero an undivided duty of loyalty or prioritizing his interests. It's all about what was bargained for here, and inalienability of a long-term income stream was at the core of the bargain.
But isn't that the purpose of the legislation, to put the role you would put on them on the court? So the court acts that way. I mean, the court understands that these things have non-assignability clauses. The whole idea of this is you get a neutral magistrate to come in and look at this thing, and if there's a real hardship here, they grant it. If there isn't, they don't.
But the court is looking at something else, which is whether the deal is in Cordero's best interest or in the payee's best interest.
And what do you want the company to look at?
We would like
stopping him from doing this.
The company, we would want them to consider the overall terms of the bargain and whether their acts destroy the contractual fruits.
But isn't the court in a better position with respect to these statutes? I know in New York, in my experience, the owner of the structured settlement is brought before the court. And the court is making a best interest determination based on some of the complaints you have here, that his IQ or his functionality was affected by the lead, et cetera. The trial court is in a better position than a settlement or the company that's holding the settlement.
Well, Your Honor, respectfully, the SSPA court wasn't in a better position. It didn't have information about Cordero's cognitive impairment. Transamerica did.
Whose fault is that?
I mean, that is it was in the SSPA record. Cordero in 3 of these, and in one of them submitted an affidavit that he couldn't even find the settlement agreement. There was missing documentation in others.
When the settlement was established, it was understood that they were going to ensure that there was a stream of income that would come available to him at the age of 18, and they would prevent that the holder at the time of the income stream, would prevent him from doing anything to not have that in existence.
No, I think that goes farther than the duty that we're saying exists. We're saying there was a duty at a minimum to review statutorily required communications because unassignability was at the core of the bargain here. When they were being asked...
But was it to his benefit or was it to the company's benefit that assignment clause was there?
It was for both of their benefits. There were 2 different assignment clauses here.
Can't you waive your right to enforcement,
So,
even if it applies to both?
So if it benefits both of them, and even if they could theoretically jointly waive, at a minimum they would need to consider what they were being asked to do here. They admit, it's undisputed, that they didn't read anything. I think Dalton teaches us that under the implied covenant, you have to at least exercise discretion in the first instance in a situation like this. They just blindly consented in exchange for $750. And even once you exercise discretion in the first instance, you have to do so in good faith. And here, they could have done what all of their peer companies do, Berkshire Hathaway, MetLife, Independent Life, as we allege in paragraphs 27 and 28 of the complaint on page 9 of the appendix. They all go through a simple checklist. This is not a heavy burden. It's pretty minimal.
So why not ask the Florida courts to set aside the transfers?
We chose to sue Transamerica for something that occurred before the Florida court proceeding here. It was an initial breach. I mean, I take it that would be an option, but we think that there was a separate breach of contract that we could vindicate in a breach of contract
If
proceeding.
we agree with you, aren't we just undermining the Florida courts who found that this was in the best interest?
No, Your Honor, and Transamerica actually raised this argument already in federal court in the Rooker-Feldman challenge, and the district court rejected that and said that what Cordero is challenging is something different. It's at a point in time before the SSPA proceeding. It's not necessarily a finding that the transfer was or wasn't in his best interest. It's a finding that Transamerica didn't uphold its end of the bargain to exercise its discretion before consenting to deviate from the core contractual.
So you're saying that Transamerica was essentially required to prevent Cordero from breaching the contract?
No, Your Honor, not that they were required to prevent him from doing so, that before they consented to deviate from the contract, they were required to understand what they were doing and why they were deviating from these core contractual.
Cordero, I'm sorry, goes into court with a guardian and says, I need this. This is in my best interest. This is what this statute is designed to do, is to allow him to go to a court to have this. And you think that company has to make a decision to prevent him potentially from trying to do that?
Well, Your Honor, he didn't go into court with a guardian here. He wasn't even physically present at any of these hearings. The factoring company went in with a signed stipulation from 3 lawyers from Transamerica who owe a duty of candor to the court and said it was okay for this transaction to go forward, knowing full well, based on what they did in the Green case in the same courthouse, that, you know, they basically...
But there was a court that made a decision. I know for a fact in New York, we, as judges, have the owner come before the court. Inquiries are made. In this particular instance, the Florida court made a determination that it was in his best interest without him being present. That is the fault of the structured settlement company? I don't understand.
The structured settlement company or the insurance company was in a unique position here. They had access to their own files. They had access to these papers. They should have at least read them and responded appropriately. The statutory scheme specifically contemplates this.
When
It
you say
gives-
unique, what do you mean by that?
They had information about Cordero's underlying injury that wasn't
So
in the
you're saying
record
when
here.
they entered into the structured settlement agreement to be, the original holder, to hold it, they were agreeing to be responsible for him based upon their understanding of his medical records?
No, Your Honor, but it would have been very easy for them to see this. It's you know,
So where are you getting the duty from?
the duty comes from the idea that the parties placed unassignability, inalienability, and a long-term income stream at the center of the bargain here. And so you couple that with the idea that Transamerica is being asked to exercise some discretion to deviate from these core terms, and they have to at least understand and consider what they're being asked to consent to before consenting.
So should Cordero or his representative, if he has one, have gone to Transamerica, to the defendants, and said, look, this is what I want to do?
Well, Cordero...
Explain why, so that they can make a decision?
In some case, that might be possible. That wasn't possible here. Cordero didn't even understand what he was signing. He didn't know to go to Transamerica. He couldn't find the settlement agreement, as he said in an affidavit in one of these. Transamerica is an interested party under the SSPA. They received this information.
So should the question in part be reformulated to address perhaps particular needs when it involves someone like Mr. Cordero who has specific cognitive limitations?
Well, Your Honor, I think it informs how the duty plays out in practice, right? When Transamerica looks at its own files, does it withhold consent? But it doesn't change the initial scope of the duty of what they have to do, which is read what is being sent to them as required by statute as part of a court proceeding.
Could
where-
they not rely on the fact that there was a court that ultimately would review his best interests?
No, I don't think so, Your Honor, especially here. I mean, Transamerica knew that courts in these situations sometimes don't have all the facts, right? In the same courthouse in Greene, within days of this, they were objecting to a different transfer because the court there didn't know that there was a no power clause in the structured settlement agreement. I mean, the SSPA is a statutory mechanism that it's in place, but it is considering different things. It's not necessarily considering the checklist of factors that, you know, other companies go through in
Did they
considering
have to
whether
take a
consenting.
position? Or did they merely have to present the court with certain information? So
They
we
could
take
have-
no position, but the court may want to know this.
I think that would have been an acceptable response. It might, depending on how they reacted, it might be a fact question, but it seems certain that, and we say this in our brief, that a discharge of its obligation of good faith could be simply to alert the court to certain key facts.
So I have two questions for you. They're unrelated, so let me take them one at a
Sure,
time.
Your Honor.
The first is, in view of the legislation, the SSPA, which is around the country roughly the same form, right? Is it possible to write a structured settlement agreement so that a court could not agree to an acceleration or a sale?
Yes, I think theoretically.
Or does the legislation override whatever words you could put into an agreement?
No, the legislation doesn't override that. I mean, I think there might be constitutional avoidance issues under the contract clause if it did override pre-existing contractual arrangements. But even putting that to the side, Your Honor.
So there's some way you could write an agreement to prevent an SSPA court from approving a factoring arrangement?
I think you could, but the agreement here was written before there even was an SSPA, which is why it's an unwritten duty that we're seeking to enforce here.
Yeah. And then the second question is, you said earlier, I think, that the provision in question was for both the benefit of both the structured settlement company, insurer essentially, and in this case, Mr. Cordero. But as I read the provision, it really has two very distinct pieces, one of which I think benefits one and one benefits the other. That is, the IRS rule requires that the payments not be accelerated, deferred, increased, or decreased, just those words. And those words are part of what's in the agreement, right? But it doesn't require the inability to sell or assign. That's not part of the IRS requirement. Those seem to me, if there is a benefit to the insurer, I'm not sure what it is, those seem to me to be added just for the benefit of the beneficiary. Is that a fair characterization?
I think that's fair. I will note, Your Honor, in all candor, my friend cites a Treasury regulation that says there need to be certain restrictions on transfers, so that might also be part of the tax benefit. But regardless, I mean, even if we were thinking about whether the restriction on assignment provides a tax benefit to the insurer, as we note, that also benefits Cordero because it solves the problem of creditworthiness and encourages a creditworthy counterparty to step in and decide to make these payments over 30 years. That's noted in several sources, including the Hindert and Winslow article and the Western United versus Hayden case out of the Third Circuit. So that's another benefit in addition to the benefit of the no power clause, which, as the court's informant and Callahan noted, protects payees like Cordero by preventing them from binging away the long-term income stream that is at the heart of the contract here.
Can I ask you the reverse? Let's suppose Transamerica stepped in and said, you know what, we're not doing this. It's not in his best interest. We're reviewing the records and we're deciding we're not going to go forward. Can Mr. Cordero say, what are you talking about? We're now going to sue you because it is in my best interest and a judge has already decided that.
Well, Your Honor, I don't think there would be a good faith claim here. Part of what's happening here is Transamerica is accepting a fee from the factoring companies and essentially staying silent and just blindly consenting. I mean, that smacks of bad faith.
But you do know, in some instances, the reason that the sales are permitted is because there are sometimes circumstances wherein the beneficiary needs the money, faces homelessness, and other circumstances. So what you're suggesting is it can't be touched no matter what?
That's our read of the no power clause, but it's even if they were right and the no power clause allows joint waiver here still, there would need to be a joint waiver in good faith. So maybe in a circumstance like that, there could be joint waiver in good faith approved by the SSPA court, but there is nothing like that here. This is a case where Transamerica says it acts in good faith by doing absolutely nothing.
So it's all on Transamerica?
No, it's not all on Transamerica, Your Honor. There's, of course, still the SSPA process. We're saying that this is a complementary duty to the SSPA.
As a policy, what would happen if we impose this duty? So now in the future, they get these, so are they going to say, come in and, as I think Judge Troutman's suggesting, just say no? We don't think this is a good idea, in which case if the court agrees, you'll sue them and say that was bad faith to stop me from doing this. Or they'll say yes, you should go ahead and do this, then you sue them and said you said this was okay, and now that was bad faith, and I don't have any money now. So what's the policy outcome of
Well, I don't think that someone like Cordero would come in and sue them if they withheld consent and the court ultimately approved it and the transfer went through anyway. I don't see what the damages are there, Your Honor.
You made a bad faith representation to the court. You're doing that to protect yourself.
But I don't see the harm there. We don't see cases like that with Berkshire Hathaway, MetLife, and Independent Life who have this policy in place. Independent Life has a guide on its website about how it goes through this checklist in all cases. I don't think that the policy implications that you're envisioning, Judge Garcia, would come to pass, given that they haven't so far, and this goes on in the industry.
What if in the SSPA proceeding, they simply tendered their file to the court, a copy of it, and said, this is everything we know? Is that enough?
That might be enough, Your Honor. Again, there might be factual questions. It depends what's in the file, but yes, that is potentially.
Well, I guess what I'm getting at is, are you trying to impose on the insurer a duty to find out some new facts?
No, absolutely not. They don't need to find out any new facts. This is a minimal burden based on papers that they already have. So what they receive as part of the SSPA process and what's in their own files. They don't need to go out and do any sort of independent investigation.
So you see it as a duty of disclosure of that information that may be of assistance to the court in making a best interest determination, not a duty to advocate a particular position. Am I understanding you correctly now?
Well, we see disclosure as one possibility. We characterize it as responding appropriately. So it might be informing the court of facts that the court doesn't have. It might be withholding consent just based on, its own view of the facts. It might be advocating a position as Transamerica.
When is it one of those might be's?
It depends what the appropriate response would be in the circumstances. I think actually any of those would have been appropriate
But that turns
here.
on what kind of duty you're trying to impose on them, right? I mean, which is unclear.
Well, the
It'd be simple
duty,
enough to say they have to turn over what they have. And they don't have to know anything else, and they don't have to take a position, but they at least have the court the information they have. That I understand.
yeah, so again, Your Honor, we think that would satisfy the duty here. But what doesn't satisfy the duty is blindly consenting, not even looking at their own files, understanding what they have. I think turning this information over to the court would satisfy.
You're saying, in your view, the duty of disclosure is the floor, but in a particular case, it might require more. And in this case, did it require more?
I think in this case, it probably didn't require more had they turned over information that said, look, this is somebody who's severely cognitively impaired. He entered into the original structured settlement through a guardian. Here's our information on this. That probably would have discharged their duty here. Obviously, we're at the motion to dismiss phase, so saying this necessarily as a matter of fact that would have discharged their good faith obligation is a little premature, but I think that likely would have, Your Honor.
Thank you, Counsel. You have your rebuttal. Go ahead,
Thank
sir.
Thank you. May it please the court, John Nyman here for respondents. In light of the arguments my friend made during his opening, it may be helpful to circle back to the issue of who my clients are and what role they played here. My clients are financial services companies whose role here was to simply do two things that from a distance may seem relatively mundane: issue an annuity and then administer the payments paid under it. Their role here was simply not to be a guardian ad litem for Mr. Cordero. These contracts...
What about the claim that other companies do what they're asking?
As Mr. Eisman suggested, this case is at the motion to dismiss phase. We have allegations in the complaint concerning those things. They're the sorts of things that we would dispute as a factual matter. At least we certainly don't concede as a factual matter are going on currently. But regardless of what other companies are doing, the fundamental question before the court is, what does the law actually require my clients to do? And there are really three sources of law on that front. One's the contract, the second is the implied covenant, and third, importantly, are the Structured Settlement Payment Acts that have been enacted by 50 states in this country. Those
Counsel,
particular statutes...
what was your company's role in this court proceeding in Florida? What did you do?
So, as I suggested at the outset, my company's role in this entire matter was simply to administer the annuity and to issue it.
But did you say to the court?
So in each of those proceedings, my clients signed a stipulation saying that they did not object to Mr. Cordero's petition. They didn't encourage the petition. They didn't solicit the petition. And in terms of their role, the role that the SSPAs...
Has your client ever objected in a proceeding like that?
My clients, there's evidence in the record that my clients have objected in certain proceedings, but when they do, for example, in the Green case, the objections tend to turn on the things that relate to my client's role in this process. In other words, the financial details concerning the annuity and whether the transfer is, for lack of a better term, going to mess up the financial administration of the annuity. Their role is not to play guardian ad litem.
That's not clear enough for me to understand what that is. Messing up the financial.
So when a petition comes in the door, what my client needs to know in order to make sure that the financial administration is going to not be interfered with by the transfer are things like, is the person who is making this request actually the payee under the original qualified assignment or under the original settlement agreement? Is the money there? In other words, is the payee asking for a transfer of money that has already been transferred to some other company or has simply simply isn't there under the annuity? Are there competing claims by different companies for a transfer? Those are the sorts of things.
It doesn't include determining whether or not they have the capacity to reach an informed decision.
It does not, because that's not my client's role here. Now, there are parties whom the statute envisions having that role. One is the factoring company itself, because unlike my clients, the factoring company actually will have direct interaction with...
But if they have no incentive to do so because they want the money,
well, they ought to...
and Mr. Cordero, someone like Mr. Cordero doesn't have the capacity to fully appreciate the consequences of this choice, aren't your clients the only ones who have the information that a court would need to make a proper best interest determination?
No, I mean, I don't think that's the case. I think the factoring companies are going to have the direct interactions with the payees that my clients won't have, because again, my clients are playing this role of financial administrator, not, they don't have access to information about Cordero's employment history, his health history, his education.
And you didn't
and
have
the
in the
like.
record these cognitive limitations?
Well, I cannot represent what information my clients have either on this record or in the general mine run of cases, but I do think that the role that these sorts of entities play is much more along the lines of financial administrator, not fiduciary, not guardian ad litem, not trustee for the payee in these circumstances.
So then why are your clients invited to address the court? It sounds like, for your purpose, there's no reason to address the court.
Well, the reason why my clients are invited to address the court is that they have this enforceable right against assignment of the policies, precisely because assignment of the policies could, in theory, entail these sorts of financial problems that would, again, for lack of a better term, mess up the administration of the annuity, could have tax consequences, or could otherwise lead to a situation where the annuity isn't being processed properly. My clients have the right...
You're not there to advocate for the best interest of someone like Mr. Cordero. You're looking out for the best interest of your company.
Well, at least for the best interest of the continued administration of the annuity. That's exactly right. And the reason, and the SSPAs...
But there may not be a continued administration, right? That's the point. He's selling it out for way below what it's worth.
But in circumstances where the annuity is
And your clients are
sold...
getting some payment, nevertheless.
Payments will continue under the annuity. They're just going to someone else. But I think that we can tell from the structure of the SSPAs that that's exactly the role that the legislatures envisioned my clients having in this process. How do we know that?
The person who's not injured, not getting the full benefit of the bargain. Or the entities, I mean, these entities are not injured. They're just companies, right? The factoring entities. Whereas Mr. Cordero, at least, is the injured party. The settlement exists for his benefit. Everybody else seems to be making some nice money there.
The settlement no doubt exists for Mr. Cordero's benefit, but the question here is whether my clients have an obligation under either the common law or the SSPAs to make disclosures or to take measures that would result in the enforcement of the non-assignment provisions against Cordero. So the common law doesn't provide that.
When you're invited, let me go back to this issue about what invited to respond to the court, you're saying that, what that would be to say, well, look, this is how it'll muck up the whole annuity process. That's all the responsibility that your clients have.
We really don't even have that responsibility. The responsibility is simply to say yes or no, we object to this assignment, or we don't object to this assignment. And if my clients had a deeper responsibility to look into Mr. Cordero's health condition or his economic condition, one would think the SSPAs would read differently, right? One would think that the SSPAs would say that it's on my clients.
Let's say this is not about selling his rights to it. Do you have at all any duty or responsibility otherwise to be up to speed on his health condition for purposes of the administration of the annuity? Do the defendants ever do that kind of investigation or scrutiny?
I can't make representations on the record about whether defendants ever engage in that sort of scrutiny. There are certain kinds of annuities that are based on the life of the annuitant, and it's often very important for the annuity company to be aware of whether the annuitant is still alive in order to administer the annuity correctly. But in order to administer the annuity, one need not know things about the health, the general health of the annuitant, or their situation, their financial situation, or the like. One just needs to continue paying the annuity to the person to whom the rights have been assigned, whether it's the original.
It's a little, I'm not asking about knowledge about the Mr. Cordero or anybody like him for the moment. Assume you don't know anything about that. It still strikes me as a little unusual to be a party to an agreement that says it can't be assigned, and then to be asked by a court about assigning it. Right? I mean, in a different context, at least, if I were a party to an agreement like that, I would say, wait a minute, the contract says it can't be assigned. So do you understand the SSPAs to overrule that language in the contract?
Not necessarily, Your Honor. The reason why that language in the contract can be overridden is that the enforcement of those provisions lies in the obligor. In other words, here, Transamerica Annuity, such that if a petitioner wants to go and transfer payments under the settlement agreement, if my client doesn't raise an objection, if my client doesn't seek to enforce the non-assignment provision, sort of on the theory that it will be okay for the financial administration of the annuity if the payment transfers goes through, there's no problem.
A mutual
there.
waiver of a contractual provision is what you're saying.
That's correct.
And in the past, you could do that, but now you can't because of the law. Now the court has to approve that.
That's correct,
Right.
Your Honor. But it's telling, I think, in terms of what my client's responsibilities are there, that the law, for example, in New York expressly says that once the transfer happens, my clients are released and discharged from any liability, any and all liability to someone like Mr. Cordero for the transferred payments. If it were on my clients to look into Mr. Cordero's economic, educational, and occupational conditions, then one would expect, number one, the statutes to say so, for the statutes to say that my clients have a duty to come forward.
The judicial determination about the best interest turns on the court having all the information it needs to be able to make that decision. So to the extent that you have some of that information in the records, why isn't there at a minimum a duty to disclose?
The reason, there are really two reasons. One is the common law doesn't create that duty. But the second, and I think the clearer answer, is in the SSPAs itself, or the SSPAs themselves. If the SSPAs impose that requirement on my clients, they would say so. The SSPAs impose all sorts of requirements on the other parties to the structured settlement transfer transaction. They don't impose that requirement on my clients. And then they say, the New York statute says expressly, that once the transfer happens, once the judge makes their determination of best interest, my clients are released and discharged from any and all liability for the transferred payments.
At the time that the structured settlement was entered into, Cordero was 5 years old. Other than that information and the term and conditions of how it to be paid out in the future, there's no requirement that your client get any updates as to the status of the beneficiary.
That's correct, except to say that, if Mr. Cordero had moved, my client would need to know where the checks were to go on a continuous basis. But otherwise, no. That was not the role my clients were playing in either in the original settlement transaction and certainly in the process that led to the Florida court's approval of the structured settlement transfers in this
Excuse my
case.
ignorance with this question. Once Mr. Cordero sells the rights to a factoring entity, can that factoring entity negotiate with you to avoid the installments and just get a lump sum if if your clients, excuse me, waive the well, it's not the anti-assignment, it's not that provision, but agreed to a lump sum as opposed to an installment, or it will always be satisfied, this assignment, this sale, through the installments? They can never accelerate.
I believe, Your Honor, and this is me speaking completely off the cuff, but I believe the problem in that circumstance with accelerating
Yeah.
payments would be, as I mentioned earlier, it would mess up the administration of the annuity, all of a sudden the tax benefits, I imagine.
Yes, I see the
associated
tax
with the-
issue for sure. Yeah.
with the annuity would go away. So, perhaps there would be a right to accelerate the payments, but if so, it would involve
Also
all
depend how-
sorts of collateral consequences that
How many payments are left and whether or not, in the end, it's more beneficial to end the installment process as opposed to have a lump sum. Correct? Isn't that part of your answer, that there may be all these other collateral consequences, but of course your client might actually go through that analysis and conclude that it makes sense now not to continue with the installment?
I suppose I don't know of any examples of that sort of thing happening.
Fair enough.
Your Honor.
Thank you, counsel.
Thank you.
Thank you, Your Honors. I'd like to start with the point about the other companies and what they do. We're on a motion to dismiss. We're all bound by our allegations. The other companies do that. And that fact is important because it is powerful evidence that insurers and annuity issuers understand that they were operating in a market that is riddled with factoring abuse.
In those other companies, do they take a position, or do they do what I understand now you're saying should be done, which is disclose to the court information they have about the cognitive abilities of the petitioner?
My understanding is sometimes they take a position. I know Independent Life, for one, will object if it sees certain things like someone with a cognitive impairment who is waiving the right to independent professional advice.
In that case, do they have to weigh the needs of the petitioner? So let's say that it was this case, but the person needed a life-saving surgery they couldn't afford. Should the company come in and object, or do they need to weigh the need?
I don't think that they waive the need just based on what I've read about it, but I think if they actually weighed the need and undertook some good faith analysis here,
But
that
would they be required then to weigh the need, in your view of the duty?
No, I don't think they would be required to weigh the need. I think they are required to go through like a very minimal checklist to look for obvious signs of sort of factoring abuse here, all of which were obvious on the face.
So was this company supposed to get health updates? The agreement was originally entered into when the beneficiary was 5. So does the contractual agreement provide that they're going to get these updates?
It does not. Your Honor, the point is that the underlying injury involved cognitive impairment. It was lead poisoning. That was information that we allege that they would have had in their files and they would have been easily able to detect. Just take into
But they're different, they're varying degrees on how it affects individuals. It doesn't affect all the same.
Sure, but so even if they brought that information to the court's attention and said, look, this is a cognitively impaired individual, the court is then going to play its role and hold a hearing, as you said, Your Honor, and so can inquire into this. The court didn't have this information at all. And just to take their position to its logical extreme, I mean, they're saying they have a right to waive without even looking at their own.
The court didn't even have the original agreement that said this was a structured settlement that was established based on lead poisoning?
So
Which would make it clear, arguably, that impairment might be an issue
Well, so
for the court.
the
to
agreement
know.
itself doesn't mention the underlying injury, and the court in 3 of the SSPA proceedings didn't have the agreement at all, and had no information about Cordero's underlying injury. And, if it was even worse, let's say it was dementia, it would, and, the person had no capacity to consent, Transamerica's position would still be that it could blindly sign on the dotted
So the roles of
line.
these state regulations don't matter. It's the holder of the settlement agreement who's responsible.
The state regulations matter in setting forth a regime for a court to judge best interests. We say that there's a complementary contractual regime here that requires a different but complementary duty on the insurance company to read statutorily required communications and respond in good faith.
And one can't substitute for the other.
One doesn't substitute for the other. I think they work in tandem. And, we're not asking Transamerica to step in and exercise its discretion in place of the court. We are asking it to exercise some discretion in the first instance. It admittedly exercised none here.
But what if there's a difference in opinion? Then who wins? I mean, aren't we enabling courts to do this, and shouldn't the courts be the ones who are making these decisions? I mean, you're absolving the court of it, saying they didn't have this information, and then imposing upon Transamerica this duty to get the information, which seems unfair, frankly.
Well, Transamerica has the information and could give it to the court. I don't think it's a question of who wins. If Transamerica withholds its consent, it's, up to the court to decide what to do in that situation. If Transamerica gives additional information to the court, it's ultimately may factor into the court's best interest determination. It's not saying that Transamerica is the ultimate gatekeeper here. That is the court. Transamerica has a duty before court approval to read what it is required to receive under the statute, to read its own files, and then decide how to respond in good faith.
Well, wait, to read its files or just to turn the files over?
Well, it could do either, we think, Your Honor. But I think reading its files would have accomplished the same end here. Other companies do that.
Let's say the decision from this court is not favorable to your client. Let's just say that. And you lose in the 11th Circuit. Case ends. Is there any obstacle for you to go? I know you made this choice. Is there any obstacle for you to go to the Florida courts?
We may be out of time there, Your Honor.
Okay.
So I think there might be an obstacle there. But regardless, the reason we chose Transamerica as a defendant is we think Transamerica did something wrong. It wasn't.
But you also thought the factoring company did something wrong here.
The factoring company did something wrong, and it is not as though the factoring company is getting away scot-free. They're subject to Transamerica's third-party complaint
Why
for
didn't you sue them?
indemnification in this action. Frankly, Your Honor, we wanted to vindicate our rights against Transamerica. We've seen situations like this happen. We thought what Transamerica
Why couldn't you
was
sue
doing.
both of them?
Transamerica was, sort of a reliable, established defendant. Factoring companies sort of come and go in the night, and so, but, that wasn't really the driving force to sue Transamerica that might have affected the decision not to sue the factoring companies also.
Thank you, counsel.
Thank you, Your Honors.